Mike, just in case. We also sometimes try to point it away from us in case we, sneeze or whatever. All right, with that, let's go ahead and get started. I'm going to call this the Friday, December 20th, 2024 meeting of the Work Group on Common Interest Communities and HOAs to order. All right, we do have a quorum for the record. And then what we want to do first is go ahead and approve the meeting minutes. Is there any discussion on the meeting minutes from December 6th, 2024? Okay, hearing none. Does anyone want to move the minutes?
I move to approve the minutes.
Thank you, Emily. Thank you, Member Murray, for that. And with that, all those in favor of adopting the minutes, please say aye. Aye.
Aye.
Those opposed? All right, the ayes have it, and the meeting minutes are approved. And we will move on to the next order of business for today. I will pass it over to Ms. Pollock to share today's agenda, which should be in your packets.
Thanks, Madam Chair. So for today's agenda, right now we're in the welcome and introductions. In a moment, we'll switch over to public testimony. And we have 3 people who have indicated ahead of time that they would like to testify. Afterwards, if others would like to testify, they can approach the testifying seats there. Then we'll hear a presentation on the national perspectives on community living issues from Ms. Heather Morton from the National Conference of State Legislatures. And following her presentation, we'll invite questions and answers from the members of the work group. And following that question and answer period, we'll hear 2 presentations by subject matter experts. The first is Mr. Chris Charbonneau, who is the president of the Minnesota chapter of the Community Associations Institute, or CAI. And we'll do both subject matter expert presentations before we do Q&A. The second subject matter expert presentation will be from Mr. Nick Morrison, senior attorney at Southern Minnesota Regional Legal Services. So after that, we'll do Q&A for both the subject matter experts, and then we'll set aside some time for recommendations and discussion, followed by adjourning, and then the next date and time of our next meeting.
All right. Thank you, Ms. Pollock. All right. Just a quick reminder at the outset for anyone who may be new, the purpose of this work group is to study the prevalence and impact of CICs and HOAs in Minnesota, how the existing laws regulating CICs and HOAs help homeowners and tenants to access safe and affordable housing. Couple quick housekeeping reminders. I do want to mention that we know that this topic is fraught with emotion and lots of passion. So we want to remind all the members, testifiers, and anyone in the audience to treat each other with dignity and respect at all times. Please direct all comments through the chair, not directly, and so that we can have a smooth discussion. Time limits. Particularly for the open public agenda, we do have some time limits here. Mr. George will be timing that. The alarm will go off at the end of your 3 minutes. When that happens, if you would be kind enough to please wrap up your final thoughts or comments so that we can make sure that we have time in the agenda for everyone who would like to speak during that segment or that segment. If necessary, the speaker or the chair, will ask you to wrap up your comments as well. All right. Please note that our agendas are structured to bring speakers to provide information for the things the work group is tasked at studying. The expectations are that each member around the table here, each member of the work group, I should say, for clarity, will participate in discussions and help guide the work being done in this committee. They come from all walks of life and all different organizations, including members of the general public. With that, we also want to note that presentations and materials by the speakers and testifiers are their own. They are not the opinions of this work group, nor is their testimony, but those will all be made available on the website for anyone to review. And the recordings of this session will also be made available there as well in case folks miss the session. I will also mention that our second listening session did happen in Maplewood last night. So I want to thank everyone for coming out in the cold and the slow traffic to get there. We did have a decent turnout. And the audio recordings of that will also appear on the website for anyone who missed it. And we are trying to, thank you to Mr. Heller who appeared. We are trying to figure out how to get a transcript of that audio recording to make available as well, in case there are folks with disabilities who may need a written copy of that. All right. With that, let's go ahead and jump right in. For the public testimony segment, we have Adam Gunther of Fairway Meadows Manor Homes to testify. If you'd like to go ahead and come up to the testifier table, please, for the record, specify your name, your city, if you have an affiliation with any sort of board or what have you, and then what your association is, and then go ahead and proceed with your testimony. Mr. Gunther.
Hi, my name is Adam Gunther. I'm the president of Fairway Meadow Manor Homes in Woodbury, Minnesota.
And I'm Lori Curl, and I'm a member at large of the same board at Fairway Meadows Manor Homes in Woodbury. Would you like the additional information as to our property management company, et cetera, right?
Yes, please. And Gloria, could you please spell your last name? Because I do not have you listed on. Oh, I'm sorry.
That's okay.
I must be having a older version. My apologies.
Okay, sorry. No worries. We're gonna do this together and we're gonna do it quickly for you because I know everyone's minds are probably not 100% here. It's this time of year. We submitted supporting documentation. We are not going to go into all the detail. We're not going to blast you with lots of statistics and numbers. Those are all in our supporting documentation. The main reason we are here is we are in a really dire situation. We are stuck, if you will, with our current management company who has repeatedly coerced us into doing projects from which they will benefit with their subsidiaries. Gas and Property Management is our provider right now, and we are part of a master board, and we can't get out of our contract because they voted, the other two communities, sister communities voted against that. The other two committees the other two properties are they're not like properties. They're both single family homes so that they need fewer services. And so they want to keep their number low and they don't want to go through the process. They didn't want to go through the process of finding another one. We use the lion's share of the services. And what we're really looking for today and hoping that you can help us with is really if we can have some type of a universal contract that would require property management companies to be fair and instead of our main issue is conflict of interest. And we are really in a quandary right now. So we also would like a way to settle disputes between HOAs and property management companies. We never really feel like we know who we can go to. The attorneys they provide are their attorneys. And it's very difficult to find attorneys that have the knowledge that aren't affiliated with the property management company. So, and then lastly, we would like to, lastly and foremost, we would really love to see legislation that would prevent these companies, these property management companies from self-serving recommendations and unfairly filtering business to their own subsidiaries for their financial benefit.
And to kind of add to that, just one of the issues that I've come on as the president with the board is we had our roofs redone prior to me coming on the board. And when I was on the board, they were coming back to us again with our fiduciary responsibility as a board, making us aware of damage from a hailstorm 8 months after our roofs had just been replaced by Gasson. Because I come from a little bit more of a construction background, engineering background, I had 2 other companies come out and basically destroy their report of quote damage, which didn't have any pictures, and prevented us from a total loss claim again from insurance, which saved us, you know, a tremendous amount of money, but also, you know, back-to-back insurance claims in that sense. That first original roof has now come out where we've had the last 3 years of maintenance issues on our roofs. A homeowner had submitted a work order for a dryer vent that was roofed over after we had routine maintenance on cleanings, and GCM Construction, which is their subsidiary, came out to quote rectify the issue that they had roofed over. And now 12 months later, after another issue with that same homeowner replacing her dryers, trying to figure out what the issue was, it was still not rectified after they had already come out and said it was rectified a year later from when it already was noticed. We hired a company to come out and do an inspection that cost us over $10,000 and found 12 other vents, which is 11, we had 12 out of 157 vent covers roofed over for the last 2 years. So now we have an engineer having to come out, which is going to cost us roughly $5,000 to $6,000 to be able to do a report for mold, moisture buildup, because the attorney that we were found, which as was mentioned, I went through 8 or 9 consultations to find an attorney that didn't have conflict of interest with Gasson, because these management companies have them all on retainer. And so from an HOA perspective, we had no one to turn to help represent us, to understand what next steps we can take, because GCM was not going to help reimburse any costs from damages that were caused by our roof that they would come out and fix. To lastly note, they did come out originally that time, the second time, to fix the homeowner whose roof was originally discovered. And after installing that, we had the third-party inspection come out, and it was installed incorrectly to code with metal sheathing over the dryer vent, which already caused blockage in the dryer vent. So this is a construction company that Gasson has subsidiaries to, owns the rights to them, GCM Construction. Not only did they install the roofs incorrectly, they then fixed the roofs not to code. So this is a licensed company that's out on the market, not doing work to code, which the state requires businesses to operate within. And if it wasn't for our board taking on tremendous responsibility outside of our careers to mitigate this risk, we would probably have another roof, millions of dollars in loans. And as you know, with the current insurance crisis going on, that 5% wind to hail would have bankrupted our association.
We're very clear now, we've become clear, excuse me, because the changing of board members and the turnover, we've discovered all this over time. And now we're kind of, left holding the responsibility. The project management was also done by Gasson Project Management. And so we paid a great fee for that. One thing really worth noting is the piece where they told us that we had to do this because replace the roofing the first time. We needed to go ahead and file the claim. Even though we now find out that the insurance company, the claim was only covering the soft metal damage, but they positioned it as, tell your members that you're gonna get it, you're gonna need a new roof in 5 to 10 years anyway. All you have to do is pay your deductible if you have an HO6.
They used a third-party insurance adjuster after our insurance company denied the claim, GavNet, to justify that. And as she mentioned, the project management, their claim to why our dryer vents were missed was because they couldn't have management on site for this scale of a project. And my response was, we paid 9% of $1 million for a project manager to be on site from Gasson, subsidiary to the construction company, which was over $100,000 in the matter of a roofing project. So in my eyes, 2 months of work at $100,000, you should be on site every single day watching that roof get done if I'm paying extra to what the contract allows. So really the 3 tiers of having a project manager, our property manager came to us and said, you need to do this, it's your fiduciary responsibility, insurance is gonna drop you. Then the project manager came to us and said, here's the bill for 10% of what a new roof will cost, and GavNet will come in and fight it for you, which of the $540,000, insurance covered $40,000 of it. So we were under the hook of $500,000 out of reserves, plus what we assessed homeowners from their HO6 policies to replace those roofs. So obviously this predates me on the board and a lot of us on the board that are there currently, but just to note that we paid over $300,000 in project management fees alone just for projects that were done around the association because of the contracts that we have been grandfathered into because of our these management companies.
Thank you. Mr. Gunther, could you repeat that last part of how much you've paid in project management fees?
Yeah, we've collectively over projects in the last, and with our time with gas, we spent over $300,000 in project management fees between roofs, breaker boards we've had done, we've had driveways redone. You know, and all of these projects, you can read in here, our decks all have had issues, in terms of the responsibility that they claim to have in terms of reporting. Our breaker boards project was halfway through completion prior to me even learning about it starting, because they just didn't report to homeowners. They didn't report they were on site, and it wasn't until a homeowner called concerned that there was someone working on their house that we learned that the project had started.
Okay. One last question, and then I know Member Murray has a question for you very quickly here. What was the time frame for that figure that you just gave me?
Gaston started with us, I believe, in
19.
2019. So this is collectively over the last 4 years, 5 years, excuse me.
Okay.
A lot of those
Alright.
details and the numbers and the figures are in the supporting documentation that we submitted.
But we would like to give you any additional information or anything that is in here. One thing I do want to mention quickly is that the past president, I had a conversation with her earlier this week. She said, oh no, we did not pay out of our reserves for the roof. She said she said the insurance company paid that directly to Gas and Construction. And I spoke with the adjuster at the insurance company, and that is not true. Their only payout was the 45,000.
Okay. All right. I do want to make sure that we keep moving because we do have another testifier and we have two questions. Member Murray first, and then Member Zavadski
Thank you,
online.
Thank you, Madam Chair. Quick question. If you can submit in written testimony, the map of conflict of interest without anything subjecting you to liability, I would appreciate that to understand that web you talked about of who is on retainer.
The legal.
Yeah, like how hard it is to find an attorney without a conflict of interest.
Okay.
Yeah, I can submit all of the names that I went through, all of the 30-minute sessions, yeah.
Thank you very much.
Yeah.
Madam Chair.
I do want to be clear about one thing. I do know that attorney firms do specialize in various areas, and there may not be a large number of companies who do specialize in this area. So I just want to be clear to state that for the record as well, that sometimes it may be hard to find one just because there aren't as many that specialize in that. So
Well,
I just,
that is.
in all fairness, I want to
Yeah.
make sure that I call that out for all our attorney friends in the room.
Yeah, I mean,
Yes,
that's
Mr.
absolutely
Gunther.
correct. The problem is there's lack of representation in this field from the legal standpoint. And from that standpoint, then these management companies have used them in the past, which then, because there are very few attorneys that specialize in it, so.
All right. Thank you for that. Member Zavadski online.
Thank you, Madam Chair, and thank you to the testifiers. I'm so sorry that you guys have went through this. I just have two brief questions. You stated that you're unable to get out of the contract with Gas and Management,
Yep.
and that is because the master has a relationship with it. Do your governing documents require that the master and subs all have the same management company?
Yes.
Correct, it does. We just had
Okay.
our bylaws rewritten, and in order for us to withdraw from the master association, it would have required all of 4 associations. There's 3 subsidiaries and then the master board, so that would be 4 documentations be rewritten. The 2 other boards, as we mentioned, are both single-family homes, so they don't require a tremendous amount of HOA. They have landscaping and snow removal kind of from sidewalks. And so if we would have had to incur those legal fees to rewrite those bylaws, and then it would have required 2/3 of almost 400 homeowners to vote yes to dismembering this association. So from a volunteer perspective, I don't have time to knock on 400 doors and ask for this to understand why our issues are separate.
So to clarify, that's to dissolve the association, but to
And for management, all decisions made by our board are submitted to the master board. We can't change landscaping at our association without the master board's approval.
Just a
Okay.
reminder, please make comments through the chair,
Oh, sorry.
not directly. All right. Thank you
I
for that.
appreciate that. Thank you, Madam
Miss-
Chair.
Member
I just
Zavadski, did
want-
you have a follow-up?
Yeah, I just had one more about So who in your community approves a loss for insurance coverage? For example, you stated that you had to go with this contract. Does your sub-association board of directors approve the work being done in your community and approve the vendors?
Mr. Gunther.
That is correct.
Okay, thank you.
All right. Thank you, Member Zavadsky. And in the room here, we also do have one more question. Member Green.
Yes, just a quick question. So I'm not sure if you were on the board at the time, but when the board decided to contract the roof, were they supplied with a competitive bidding process?
Per our contract, we're required to use GCM construction if with using GAFNet. So that was if with using that adjuster, it was their choice on who they used, which was GCM.
Thank you.
Oh, sorry. Sorry.
Yeah, Mr. Gunther. I know. You know what? It takes a little getting used to. I'll be upfront with you. As a baby legislator, I struggled with that myself. But it's really just meant to make sure that we have somebody moderating the discussion and that we keep good decorum. So, but I appreciate, Member Green, did you have any follow-up? All right, thank you. Thank you, Mr. Gunther, and thank you, Ms. Curl. Curl?
Yep.
Okay, I want to make sure I'm saying it right, for your testimony. I appreciate you being here. And if you have not already signed the sign-in sheet with your contact information, please do so. We want to make sure that if there's any additional questions for follow-up, that we can get a hold of you.
Absolutely.
Yes.
To submit what they had asked for, how would do I just reach
whom?
back out to whom? we should
Yes,
send
one
it
of the
to?
staff will reach out to you.
Cool, thank you.
And that's why we want to make sure they have your contact information.
Thank
We
you.
Perfect.
appreciate everything that you're doing and your time and your attention.
All right, thank you so much. And then next on the list, we have Ms. Cindy Haas. Am I saying that right? Hazy. Okay. All right.
So I'm pretty much going to read mine. Can you hear me okay?
Okay, yes, Ms. Hazy. Please make sure to state your name, your city, any affiliations you have, and who your property manager or management company is, if you have that, if that is applicable to your situation.
Okay. I first want to thank these board members over here for all the hard work you do. This reading that I'm going to do now is my opinion. It is not my HOA's. Again, my name is Cindy Hazy. I am a member of and a board member of an association in Eagan, Minnesota. I can be referred to as Cindy if you address me. My association has many of the same experiences as those already shared. Affiliated businesses not held to accountability for poor workmanship because of conflicts of interest. We had a leaking brick wall that on 2 sides of the house was replaced 3 times at the expense of the association. And the cause was determined to be an incorrect plastic barrier instead of a felt wicking barrier. Neighboring associations' electric bills were paid with our funds to the tune of $13K. Property management failing to do site visits, reply to homeowners timely if at all, and inaccurate financials. Insurance premiums increasing and the fear that we are moving closer to the year-built restriction every year. We don't need to hash these out as these have already been covered in most of the testimony. I want to quickly share my concerns about the undefined reasonableness standard. My first big concern going forward is the suggestion that daycares, work trucks, short-term rentals may be allowed on property and how there needs to be this undefined reasonable standard applied. First, whose standard of reasonableness is right, yours or mine? Too often reasonableness is thought to mean feelings of compassion, sympathy, and sensitivity. What I see is factual, overwhelming risk and more cost to all for the benefit of one. Additional risk needs to be considered, such as foot traffic where there are no sidewalks, inattentive guests, exposure to more slip-fall incidents, personal injury, theft of work equipment, and damage to buildings and roads. Keep in mind, I come from a risk management background, so I see all these things. Some associations just aren't built for business operations. In addition, property managers are on site less and less. So who deals with the parking complaints, the grounds damages, the littering, and the noise complaints? The board? This is setting up a board and HOA to fail and exposure to even more contentious situations. My second big concern is the suggestion that there should be more action to delay foreclosures. Again, the suggestion that this undefined reasonable standard is missing, as though boards are insensitive, lacking heart, and out to take someone's home. What I see are the facts that delaying does not set the homeowner up for success and in fact harms them. I come from a collections background as well. What I see is the other homeowners being expected to function as lenders carrying others' debt. Is it reasonable to ask board members to listen to explanations and consider payment plans when they are not licensed collections agents? Isn't this a conflict, illegal, and unreasonable to put them in this pickle? Attorneys should be involved in and negotiate payment plans as soon as any dues-related debt hits 90 days, no matter the amount. My third big concern is the submission to restrict fees and fines. If I recall correctly, the fines were being applied to homeowner accounts when the homeowner refused to act reasonably in a board meeting. Not all of these accusations seem to be correct, but there must be a portion based on the volume we've heard. Am I correct that there is already legislation that states a homeowner can be fined for being disruptive during a board meeting? It seems reasonable that there was a basis for this original legislation. If the right to fine when they are legit is taken away, how does the board regain control of board meetings? Thankfully, our association has not had this experience. As a property management previously, I have seen this. But reality is sometimes the board doesn't inform of the next board date. Sometimes they meet in a garage, or sometimes they have closed meetings. This is not transparent. But how, again, does the board conduct business and also serve the other 99%? In closing, I am not a fan of the undefined reasonableness verbiage, which I feel has been weaponized against boards and used to shame. In my experience, boards work hard to nurture a community with like interests and diverse wants. Thank you for your time, Cindy.
Thank you.
I did write a 6-page written testimony as well. Unfortunately, I was not able to provide it before the meeting. And so there's many more
Yeah.
bits of information from my perspective in there. Thank you.
Thank you, Cindy, for your testimony. We will collect that and make sure that it gets to members in their packet so that they can review that. Thank you for your time. All right. We do not have anyone else on the list. Before we move on to other business, is there anyone else in the room who wishes to testify? All right. With that said, we are going to go ahead and move on to the next section of business for today. Our first presentation, we have Ms. Heather Morton from the National Council of State Legislators here with us. The National Council of State Legislators is a bipartisan body, which I'm sure she will tell you herself. But I want to make sure that folks are aware a little bit of what they do. They work with legislators around the country from multiple states on helping us to craft better legislation, to better take a deeper dive onto issues and concerns, and be able to helpfully make smart decisions in our legislating. And with that, I'm going to turn it over to Ms. Morton.
Good morning. Just double checking that you can hear me okay?
We can. Please proceed, Ms. Morton.
All right. Thank you so much. Good morning, and thank you, Madam Chair and members of the work group for the invitation to return to speak before you again today. For the record, my name is Heather Morton, and I cover financial services issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of community living policies that include reasonable governance and some due process procedures for common ownership associations. Next slide. I know that I've covered this in my earlier testimonies, but for those of you who are not familiar with us, NCSL is the country's most trusted bipartisan organization serving legislators and staff for 50 years. Next slide. We serve all 50 states, territories, and commonwealths. NCSL is headquartered in Denver, Colorado, where we provide comprehensive and unbiased research on state policies and legislative institutions. Our office in Washington, D.C. focuses their work on ensuring state legislatures have a strong, cohesive voice in the federal system. And NCSL does not make policy recommendations, nor do we advocate certain positions to states. Instead, we promote policy innovation and facilitate communication amongst the states. Again, we do this because we believe in the importance of the legislative institution and know that when states are strong, our nation is strong. Next slide. All right, so for today's presentation, I'm going to focus my discussion on a couple of areas. First, I'll discuss the efforts to enact legislation to establish Homeowner Bill of Rights. And then after that, I'll provide examples of responsible governance requirements that are specified in statute, including examples of due process provisions and reasonable communication provisions. And now that you know where I'm going to go with this presentation today, let's get started with the Homeowner Bill of Rights protections. Next slide. So as you may recall from my first presentation back in November, the Uniform Law Commissioners drafted the Uniform Condominium Act back in 1977 and the Uniform Common Interest Ownership Act in 1982. The Uniform Common Interest Ownership Act combined the Uniform Condominium Act with two other acts to create one large comprehensive statute that deals with all three forms of real estate owned by multiple parties. And those acts were the Uniform Planned Community Act, which dealt with associations of single-family homes, and the Uniform Real Estate Cooperative Act. And since its creation, the Uniform Common Interest Ownership Act has been revised 3 times in 1994, 2008, and the most recent version released in 2021. And the reason I'm revisiting these uniform acts is because as part of that 2008 amendment process, all the Uniform Common Interest Ownerships Act's consumer protection provisions were extracted and compiled into a separate Uniform Common Interest Owners Bill of Rights Act. This Bill of Rights Act was intended for states that wanted to adopt consumer protections for condominium owners without having to adopt the other provisions on formation, management, and registration of condo and homeownership associations that are contained in the Uniform Common Interest Ownership Act. While 10 states adopted one or more versions of the Uniform Common Interest Ownership Act, only Kansas adopted the Uniform Common Interest Owners Bill of Rights Act in 2010. And on this slide, I have the list of all the statutes that fall under that Bill of Rights Act. Next slide. The District of Columbia enacted its own version of a condominium association Bill of Rights and Responsibilities in 2017. Now, looking at the slide, I admit that I'm breaking the PowerPoint rule that prohibits listing a lot of text on a slide, but I wanted to give you a copy of the statutory language so that you have it and can review it at your leisure. Next slide. Separate from the Kansas and Washington, D.C. Bills of Rights, 3 states considered homeowner Bill of Rights legislation in the 2024 legislative session, and those are Illinois, Maryland, and New York. While these bills have Bill of Rights in their bill title, they do provide different levels of homeowner protections, but none of these bills were enacted this year. Next slide. And so moving from the broader Bill of Rights protections for homeowners, I'm going to turn to responsible governance requirements that are directed at specific provisions to help with some due process or reasonable communications between the board of directors and the homeowners. And so my first example are the 7 jurisdictions that authorize payment plans for unit owners who have fallen behind on their assessment payments. The jurisdictions, they're highlighted in blue in the map, are Arizona, California, Colorado, Hawaii, Puerto Rico, Tennessee, and Vermont. And just so you know, Tennessee's provision applies to situations where the board approves special assessments for non-essential amenities. The others apply to regular assessments. Next slide. And another example that I wanted to highlight that provides due process procedures before levying fines or suspending homeowner privileges against a homeowner is the option or requirement for some kind of hearing process. I identified a handful of states that have specified a hearing process, and those are Florida, Maryland, Nevada, North Carolina, Utah, and Virginia. In Florida and Nevada, the statutes authorize that this hearing panel may be constituted with members that are separate from the board of directors. And then next slide. So finally, I wanted to highlight just a few more states that have some different options to demonstrate, some of those responsible governance provisions. And so first I wanted to highlight California. They have a statute that requires that a homeowner must on an annual basis provide written notice to their association of that member's preferred delivery method for receiving notices from the association. And that can include the option of receiving notices both at a mailing address and or at a valid email address. Then second, Colorado requires that an association must furnish a written statement that sets forth the amount of unpaid assessments that are currently levied, against the owner's unit to that unit owner or that owner's designee. And that notice has to be delivered personally or by certified mail, first class postage prepaid with a return receipt. The statement has to be furnished within 14 calendar days after receipt of that request, and it's binding on the association, the executive board, and every unit owner. And then if no statement is furnished to that unit owner or their designee, and that means delivered again personally or by certified mail to the inquiring party, then the association doesn't have any right to assert a lien upon the unit for the unpaid assessments which were due as of that date of that request. Third, in Connecticut, the state statutes specify the opportunity for unit owners to express their views on proposed budgets. The statutory language provides that notwithstanding any provision of the condominium instruments to the contrary, that at any meeting of the unit owners to consider final adoption or ratification of any proposed budget, that or even on a day prior to such meeting, that the board of directors shall provide a reasonable opportunity for all unit owners to express their views concerning the proposed budget before its adoption or ratification. And they have to make at least one copy of the proposed budget available for inspection at that meeting. Then, going back to Florida, the state legislature enacted legislation that prohibits what are called strategic lawsuits against public participation, which are also known as SLAP suits, from being filed against condominium unit owners and parcel owners by either the condominium or homeowner associations, governmental entities, business entities, or other individuals. Now, these SLAP lawsuits, these can be used as a tool to intimidate or silence criticism when lawsuits without, and because these are often lawsuits without merit and they're filed solely because the condominium owner or the homeowner, the parcel owner, has exercised their First Amendment rights in some way. And these two laws provide, what they do is they provide an expeditious process to dismiss those actions if they're filed. Then, another example comes out of Idaho, where statutes provide that no fine may be imposed for a violation of the homeowners association's covenants and restrictions unless the authority to impose a fine is clearly set forth in the covenants and restrictions. And then the process requires, so in order to impose a fine, it does require a majority vote of the board, and written notice must be provided to the member at least 30 days prior to the meeting where the board will vote on imposing that fine. And their service of the notice must be by either personal service or certified mail. And if the homeowner begins to resolve that violation before the vote occurs, then no fine may be imposed as long as that member continues to address the violation in good faith until it's fully resolved. Finally, it does limit attorney's fees and costs so that they may not accrue or be assessed or collected by the homeowners association unless that homeowners association has complied with these requirements and that the member has failed to fully resolve that violation. And then, as I mentioned, finally, on the last slide, Maryland does provide the right to request a hearing before imposing a fine or suspend the homeowner's voting privileges. In the statute, Maryland does allow for extension, it gives them up to 12 months after the original demand to cease and desist, for the original demand to cease and desist, for the homeowner to request a hearing if somehow the original violation continues or if the same rule continues to be violated again and again. Next slide. So I know that I went kind of quickly through and tried to give you some examples, but so I want to show you here are suggestions for our different ways that you can access NCSL resources. Next slide. And then here is the slide announcing the next NCSL Legislative Summit in Boston, in case you're interested in attending. And next slide. And then finally, thank you, Madam Chair, for the opportunity to provide this overview of state laws regarding homeowner bill of rights and reasonable governance, including some due process and reasonable communication examples. I am happy to answer any questions and provide additional information if needed. My contact information is available on this final slide. Thank you so much. And thank you for advancing the slides for me.
Thank you, Ms. Morton, for that. As I mentioned before, one of our intents is to try to make sure that each of these conversations, that all of our presenters are able to sort of frame issues or the topic of the day to allow work group members to more accurately kind of weigh what recommendations they might prefer or comments or questions and things like that to sort of invoke that thought process. So it's really helpful to have someone, we have been alternating between Ms. Morton, which has sort of that nationwide perspective, and our researchers here in the House who have sort of more that statewide perspective and what's actually in the statute. In this case, there is not a whole lot in statute around these issues. And so we do not have staff presenting today. So just for clarification on that. But we do appreciate the national level perspective from Ms. Morton. Does any of the members, either in the room or online, have questions for Ms. Morton?
I'm sure I have a question.
Member Daley.
Ms. Morton, I'm wondering, well, two quick questions. One, this SLAP lawsuits, what sort of claims are we talking about here? I mean, they're trying to make homeowners so they can't participate in the process, or what is that about? And then my next question is, how robust?
Lean into the mic.
Oh,
We're having difficulty
Yeah.
here.
How, like, what's the sort of spectrum of protections that you've seen nationally for homeowners who are contesting a fine or a individual assessment? I mean, I think our statute is very brief, just notice and an opportunity to be heard. Like, what's the spectrum of what you're seeing nationally in that regard?
Ms. Morton.
All right. Thank you, Madam Chair. Thank you, member. I'm sorry, was it Daly?
Yes.
Daley. Yes.
Okay, Daly, sorry. I wanted to make sure I heard that correctly. So in terms of the SLAP lawsuits, these are they're basically, what what happens is that, so like if a homeowner is going, like they're exercising their First Amendment right, or and so maybe they're making complaints or, talking with their homeowners board, or if they're doing it to the government entities or like to other businesses, that kind of thing. Then sometimes what will happen is that that other entity, right? So the homeowners association, the government, like if it's an agency, or if it's a business kind of a thing, they will basically, try to file a civil claim against that person when they're exercising their First Amendment right. And a lot of times, right, it's, and I don't know, I'm not exactly sure on sort of all the grounds that they're filing it. It could be something of like, well, maybe they're being harassing or something, trying it. In effect, basically what happens is that they're trying to shut down that person's ability. And a lot of times the argument is with these SLAP suits is that they're using it as a form of intimidation, because then it will distract the person and then they have to go to court and defend themselves on that charge. And then it takes their attention away from, what they were complaining about in the first place. So these anti-SLAP lawsuit or anti-SLAP suit laws, similar to what Florida has passed, is it's basically is designed that so if the lawsuit really doesn't have much merit and it's on its face it just is it's not doesn't have any doesn't really have anything to it, that then it provides a process for the person who's being sued to go back and say, hey, goes to the judge and say, hey, can we expedite this? This isn't meritorious. There's nothing to this. And it creates a quicker process so that then they can either dismiss the case or they can get a summary judgment and get it to go away.
Ms. Morton,
Excuse
and I
me.
know this is a tough one because you're working with the National Council of State Legislators. I know the question was originally from Member Daley about if there were any examples of what the homeowner did that violated their First Amendment rights, where these SLAPP lawsuits came into play. In your research, did you have any examples of what that might look like?
Thank you, Madam Chair. Unfortunately, I didn't go looking for any examples in preparation for today. As I was going through the statutes trying to find different examples of how things can try to be used to either improve or prevent sort of, bad relationships developing. So unfortunately, I do not have any examples of any, exactly of what would constitute, the behavior that then could trigger a SLAPP suit.
Thank you for that.
Okay.
I know that we haven't necessarily heard of specifically a SLAPP lawsuit. I know we've had a few instances in testimony of folks receiving fines or fees or things like that for asking a question, for various things and it appears that there's a pattern where the intent is really for them to quiet any dissent. And I think that does seem a little bit concerning. I don't know that we've heard any specific examples in Minnesota at this time of lawsuits around that, but I'm sure there may be some, and who knows, after this session, we may have someone come forward. But I just wanted to make that clarification. And then the second question was the spectrum of fines for Ms. Daly. I'm sorry, I can't read my own writing.
The spectrum of how robust of protections do homeowners have for dispute
Oh.
resolution processes? I mean,
Contesting fines.
Yeah,
Got it.
And thank you, Madam Chair. Thank you, Member Daley. I will say, back to the SLAPP suits, I would say that is a very extreme case. And so I don't know that there's a lot of them. But I just wanted to point it out, but it is, it's an extreme case, I think, of when those happen. But back to the question about the spectrum of the robustness of the protections. Absolutely, you are correct. There are some in some of the states, right, where they just say, there really isn't any kind of language at all about creating a method for a homeowner to contest, when a fine is being assessed. And then there are some where it's just kind of like, kind of more generic. There must be a reasonable process or that kind of a thing. And I'm seeing in some of the bills and some of these statutes that I was highlighting, that states are trying to move to create and spell out much more of a definitive process. Particularly on the states, on that slide where I showed where they have to have a hearing, those are absolutely those are examples of where they say, like they specify that notice has to be given, it has to be written, how it has to be delivered, that it can be personally delivered or it has to be by certified mail. And then they spell out how many days once the person makes the request, there may be specification of how quickly the board has to respond in terms of responding to that request for the hearing. And then and whether or not some of them specify whether or not the homeowner can have representation. So if they can have an attorney with them to help make the arguments to the board, if they can provide evidence, any kind of evidence. So yeah, so I would say for sure that the states, and I can provide those statutes for the ones that I highlighted on the slide, that they're getting into much more detailed process and they specify specific steps that have to be met in order for the hearing process to be to work.
Thank you for that. And I appreciate the question, Ms. Daly. Are there any other questions before we move on to the next set of presentations? Member Murray.
Thank you, Madam Chair. I miss blanking on name, Miss Morrison? Morton.
Morton.
Miss Morton.
Yeah.
Would you be able to shed light on, help us understand why only one state passed the updated Common Interest Bill of Rights?
Thank you, Madam Chair and Member Murray. I did reach out to a contact at the Uniform Law Commission to to verify that. I was like, there's only one state. But I think, from my conversation with their staff, it does sound like part of the problem, I think it relates to the smaller number of states who have adopted the the uniform common owner, sorry, the Uniform Common Interest Ownership Act. There's only about 10 states that have adopted it. And so, and I think it's because they already had, either they'd already done something on it. And so they didn't want to, at that time, right, they didn't want to completely scrap it and start over again. And I will say that these acts, good or bad, these uniform acts, they are very voluminous. There's a lot of detail in that. And so, that might, take time, it takes a lot of time and takes a lot of effort to get through and to get buy-in from from the legislature to go ahead and address it when maybe they could say, hey, we've already got something in place. So, and I guess, and I think it's, like I said, the Uniform Bill of Rights from the Uniform Law Commissioners, all it did was it's all it's all those same protections that are in the overall Uniform Act. And what they did is they just pulled it out so that they could then adopt that. But, in terms of policy making, right, that they might not have felt that it was something that they wanted, or maybe they felt that they had enough protections in their state. I think, based on what I've seen in the legislation from 2024, right, we saw there was only a handful of states there that are looking, that introduced Bill of Rights legislation. But I think it's something that as issues continue with homeowners associations, and other ownership associations, that, it's very possible that we will see more legislation coming down the road. And some of the stuff I think is that the states have been doing it maybe piecemeal up until now. And so maybe they're not, they might not be introducing a giant Bill of Rights law, but, in some states, right, as in my previous testimony, they created an ombudsman office, right? So they're trying to address it in smaller, maybe more manageable pieces of legislation.
Understood. I do want to say anecdotally that I do know that from talking to other legislators in other states, that this is a very robust topic of conversation. I think earlier in our sessions, we heard about 82% of new homes being sold fall under an HOA. So I think the prevalence of them has increased, as have sadly some of the issues or concerns around them in other states. Minnesota is not an island in that respect. I think many states are wrestling with this, but as mentioned here, the statute around this is pretty voluminous. It is not always written in plain language, making it very difficult for boards who may be novice to understand their roles and responsibilities, for homeowners to understand their rights and responsibilities. And so it is very daunting, I would say, at the least. And it does mean that boards in particular, particularly who have no background or knowledge in this area, often have to rely heavily on property managers or attorneys to try and decipher what that means. I will say that one of the intents of this language, and it was spelled out early on, is when we talked about things like reasonableness, transparency, fairness, and plain language, it is my intent that all of our recommendations be focused through that lens, and that any legislation that comes forward should have that intent. Because again, we are dealing with a lot of folks who are not trained, who are, volunteers, for a better lack of a term, in this area, and really having some way to help them to understand what their roles and responsibilities makes good sense. And I think that might help avoid some of the challenges we see as well. So that said, we are going to move on to the next portion of our agenda because we need to keep on schedule here. We do have, thank you, Ms. Morton, for your presentation. And we do have Mr. Chris Carbonneau here from CAI. He is in fact the president at the Minnesota chapter of Community Associations, or CAI. Mr. Charbonneau, when you are settled, if you want to go ahead and state your name for the record, your affiliation, and then go ahead and proceed with your testimony.
Thank you, Chair Bonner, Vice Chair Lucero, and the working group members. My name is Chris Charbonneau, and I live at Black Forest Condominiums, which is a 258 unit low-rise building built in 1974, located in Fridley. I've lived there for 18 years, and I volunteer on the board of directors. My experience with community living began 33 years ago. I started as an on-site caretaker at an old Minneapolis apartment building. It was important for me to learn all aspects of operations and to be a part of the community. Currently, I serve as the 2024 president for the nonprofit CAI Minnesota, which stands for Community Associations Institute. One of my priorities as president is to assure homeowners have the educational resources to be good community members and effective volunteer board leaders. It is my past experiences living in and volunteering at CICs that have shown me the value of education and getting the most out of what these communities have to offer. All CICs are different: housing co-ops, HOAs, condominiums, townhouses, but there are strong similarities as well. In my experience, both in the communities I have lived in and the hundreds I have worked with through the years, I have found the following to be true. Most HOA board volunteers want to be successful in their role and have a cohesive community. Most HOA homeowners have good intentions and choose to live in a well-maintained community with shared amenities. Most association managers work hard by guiding the board, overseeing operations, and supporting the community. Many of the testimonies I have heard before this committee seem to be exceptions to the norm. Excluding egregious behavior and neglectful acts, I really feel that more education and better communication by all parties would have helped in many of these situations. All HOA board volunteers and homeowners would benefit by taking advantage of the education resources. All communities would benefit by practicing transparency and consistent communication. To build better communities, I feel that we, CIC residents, board volunteers, and managers, need to better understand the workings of our community by being reasonable, following the governing documents, being transparent, preventing conflicts, and educating ourselves. Sometimes this means going out and looking for information. Before I joined CAI, I wanted to learn more, and I found a surprising amount of helpful information online. It's also what led me to CAI. I've included several free references on this slide that I have found helpful. In addition to these references, going back to the similarities among CICs, there are some best practices that present themselves and are commonly found in the majority of the HOAs that I see as running smoothly. These best practices have served me and our HOA board well. Just so you all know that I'm not making this up, I'll share that our building experienced a fire this past year, and our insurance carrier dropped us. Through these and many other projects going on, our community has come together. Those impacted by the fire received a high level of communication and support, and the board put out a special issue of our monthly newsletter, specifically on insurance details and the impacts it would have on our association. These seemingly small efforts made a big difference. I feel that the following best practices by boards can make any community stronger. Boards should thoroughly familiarize themselves with the HOA governing documents and CICHOA. These documents outline the board's powers, responsibilities, and limitations. Boards should maintain open and transparent communication with homeowners through newsletters, emails, community meetings, and websites. They should encourage feedback and address concerns promptly. Boards should prioritize fiscal responsibility by creating a realistic budget, managing finances effectively, and conducting reserve studies every 3 years. They should be transparent about the HOA's financial health. Boards should enforce rules fairly and consistently to support a harmonious community. They should be prepared to address violations objectively and impartially. Boards should foster a sense of community through social events, volunteer opportunities, and other activities that bring residents together. For example, hosting National Night Out and having holiday parties. Boards should, when necessary, consult with legal counsel, property managers, and other professionals to ensure compliance with laws and regulations and to make informed decisions. As a fiduciary, do the best job you can and do what is best for the association. It's not just the board volunteers that need to work on building community. Homeowners can change the community in a hugely positive way. Some best practices for homeowners include familiarize yourself with the HOA's governing documents. This knowledge is crucial for understanding your rights and responsibility as a homeowner. Read all communications. Open your mail, read your emails, visit the website, view the postings and flyers around your community. If you do have a community newsletter, please review it. And also attend board meetings and read the meeting minutes. Homeowners can also make timely payments of HOA dues and assessments. It's essential for keeping the community's financial health and funding necessary services and improvements. And always be mindful of your neighbors and the community as a whole. Be a good neighbor. If you have a dispute with a neighbor or an HOA board, strive for a respectful and amicable resolution. Always be civil. And consider volunteering for community events or serving on a committee or the board. Your participation can make a significant difference in improving your community. By following these best practices, homeowners can contribute to a positive and thriving community, protect their property values, and enjoy the benefits of living in an HOA. Some final thoughts I'd like to share with you are simply that being a part of a community, any community, but especially a CIC or HOA, requires effort to be successful. This means all parts of that community are doing their share to help towards that end. My recommendations for your consideration are as follows. For homeowners and board education, encourage voluntary education for all homeowners and board members. This approach ensures that education initiatives align with the unique needs of each community and reinforces that board members adhere to the governing documents and applicable laws while maintaining transparency in meetings and decision-making. This includes conducting open and fair elections, providing access to records, and disclosing any conflicts of interest. Promote voluntary education for realtors and CIC managers. Require housing improvement area loans in all cities. This would provide relief to the burden of high construction costs to maintain aged communities. This is especially important with recent changes in the insurance landscape. The collection of delinquent assessments and foreclosures. We need fair, efficient, and equitable methods for collecting delinquent assessments. This is to protect homeowners and community associations alike. Foreclosures should be a final resort only on common expense assessments after other reasonable attempts have been made. Consider a minimum amount. Homeowner advocacy. Have the state provide a mediation group to assist in issues that cannot be resolved through normal communications. Allow a third party to discuss the issue with both parties and reach a resolution without the need to involve attorneys or the court system. State funded or, worst case, split equally between participants. Thank you for the opportunity to speak and your time volunteering on this important issue.
Thank you, Mr. Charbonneau. I really appreciate you being here today and our conversation leading up to today as well. Thank you for that. We are going to go to our next testifier for today, or our next presentation from Mr. Nick Morrison. I'll ask him to kindly come up and then we will reserve any questions until after both presenters are done. So for the interest of time. We want to make sure we have time at the end for some of our work to look at recommendations and talk through some of that. Just to queue up what is next in the agenda. And Mr. Nick Morrison is a senior attorney at Southern Minnesota Regional Legal Services. And again, just a reminder, after Mr. Morrison's presentation, we will have Q&A for both presenters. So then we will invite Mr. Charbonneau to come back up to the testifier table at that time. Go ahead, Mr. Morrison, if you want to go ahead and state your name, your affiliation, and proceed with your testimony.
Thank you, Madam Chair. My name is Nick Morrison. I'm actually the lead attorney for the consumer unit at Southern Minnesota Regional Legal Services. I'm also a board president for the Ledgestone HOA, which is in Matamidi. Previous board president for the Point Douglas HOA. That was 124 unit. My current one is 70 units. And about a total time of close to a decade of being a board president. I'm going to talk today about some areas that 515B are lacking, that we believe that there needs to be some strength and some better definition and delineation. First thing I'm going to go into is reasonable standards. And we already talked about, we already heard testimony on that. And the first area for reasonableness is fines. Currently, 515B requires fines to be reasonable, but each HOA can determine what is reasonable. So what's reasonable to me might not be reasonable to you, okay? And there's no guidance whatsoever. Some states do provide guidance. Texas, for example, establishes a policy that is transparent for all homeowners regarding what violations are punishable by fines and what the fine schedule is. Other states cap how much an HOA can impose a fine. My current HOA right now, we have a fine schedule. We have an amount, a cap on the amount that can be fined. It's easy to do. The recommendation here is that Minnesota should require HOAs to establish a fine policy and schedule a cap and cap the amount that homeowners can be fined. It's easy enough to do. The board can get together, make a determination, and then put it out to the HOA, to the homeowners themselves. Another area that's lacking, reasonable doesn't even appear in connection with the adoption or the modification of rules. Again, this is something that the recommendation is like other states, it should require that rules be reasonable. Aesthetics. Minnesota HOAs have the power under 515B to regulate the exterior appearance of common interest community including, for example, balconies, patios, window treatments, signs, and other displays, regardless of whether inside a unit. Other states place limitations on HOAs, such as Utah, and on how HOAs can control the individual aesthetic changes to their homes. I've literally had calls where people have been limited on not being able to put a wreath up during the holiday season on their front door, not being allowed to put a storm door up, a Ring camera. I mean, various different things that you would think would be a normal and acceptable aesthetic change, not allowed. Also, I've also had complaints that have come in where boards have taken an exorbitant amount of time in order to approve or disapprove in excess of 90 days. Now, understand, there's sometimes where boards only meet once a quarter, but 90 days, I mean, if it's over 90 days, there should have been a meeting in there for them to make a recommendation of yes or no. Attorney's fees. HOAs in Minnesota can charge attorney's fees for responding to a homeowner's complaint. This is unreasonable. Attorneys, in many instances, again, we've all heard different testimony before this forum where attorneys have been charging people for providing documents that should be provided to the normal homeowners, such as the budget, such as a balance sheet, various a schedule of fines that's assessed against them. Okay, these are all things that in some HOAs they're being charged for this, and some of these attorneys charge anywhere from $400 to $700 an hour, and I've seen that. I've had people call in and talk about that. The recommendation here is that Minnesota should expressly prohibit HOA attorneys from charging fees for responding to questions, complaints, or providing basic documents. Late fees. We've heard testimony about that as well. There is no reasonable standard for what an HOA can charge for late fees. Some states cap this, how much an HOA can charge for a late fee and how much for the interest on the late fees, etc. Again, my HOA, we've got a cap on late fees. It's easy enough to do. The recommendation is Minnesota should cap the late fees. Foreclosures. An HOA can foreclose on any assessment, no matter how small. There's no reasonable standard. Some states require assessments be late for a certain period of time before an HOA can foreclose. Other states set a minimum amount that a homeowner must be in arrears before HOA can start a foreclosure. My current HOA has both. The recommendation here is that Minnesota should prohibit foreclosures unless arrears are owing for a specified time and should establish a minimum amount that must be owed before an HOA can initiate a foreclosure. The next area we've heard about today as well is transparency and consistency. 515B does provide transparency and consistency in certain areas such as notice of meetings or open meetings, but there's no transparency and consistency when it comes to management companies. HOA boards are elected and are directly accountable to homeowners. Management companies are not. And nationally, 60 to 70% of HOAs hire management companies to manage the operation of the CIC. But Minnesota law is silent with respect to oversight, regulation, and the requirements of management companies retained by the HOAs. There's a significant lack of transparency and consistency across HOAs in the state regarding the relationship to HOAs and homeowners and the accountability of management companies. As we've already heard earlier today, management companies are not held to any conflict of interest standards, as well as HOAs. No better illustration is of this gap in the Minnesota law is the recent scandal involving the Otsego HOA, where the board steered the roofing work to a contractor that was a subsidiary to a property manager. I have seen this personally in 2 separate HOAs as board president. And we ended up eliminating, that was one of the reasons why we eliminated one of the property management companies that we had and moved to another one. There are states that require licensing of management companies and hold them to a conflict of interest standard. Management companies, and the recommendation here is the management companies in Minnesota should be licensed and held to a strict conflict of interest standard. Another area to look at is basic rights. Minnesota provides certain rights to HOA homeowners, the right to vote, the right to notice of board meetings, the right to association records, albeit for a charge, and the right to a statement of unpaid assessments, again, currently for a charge. But other areas, homeowners lack basic rights. Dispute resolution. 515B gives homeowners the right to notice and the opportunity to be heard if a fine is levied. But there's no specificity regarding what rights accrue to a homeowner or what procedures must be followed by the board at such a hearing. This leads to a lack of transparency and inconsistency across the state. Other states do require establishment of internal HOA dispute procedures and the opportunity for the parties to engage in alternative dispute resolution. Some states have even established HOA ombudsperson offices. Recommendation here is to establish such an office for oversight. Require HOAs establish a fair internal dispute resolution process. Require HOAs to offer alternative dispute resolution options. The right to speak. 515B gives the homeowners the right to attend board meetings, but unlike other states, it does not provide an express right to speak. 515B should expressively provide the right for a homeowner to speak at a board meeting on the topics on an agenda and raise any issue of concern, even if it's not on the agenda. We've heard in testimony at this forum before where people have been fined for asking a question of the board because it wasn't on an agenda. That's unreasonable. The right to a payment plan. Right now, there's no right under 515B to a payment agreement if a homeowner falls behind on assessments or owes fines. Other states require that HOAs offer affordable payment arrangements. We discussed this at our board meeting a couple of days ago. And not only because people are falling, but they find out why they're falling behind. If it's a problem from an employment standpoint, whatever, there's also, there's agencies out that are provided in the state that can provide monetary relief, that can provide grants, that can provide different things to get people back on track if they are falling behind. Chances are if they're falling behind on their dues, they're falling behind on their mortgage too. So these are things that we could look at as a board and try to be reasonable about and try to give them some type of a payment plan where what we proposed at our board was a payment plan with no interest and no late fees. You know, they work out a payment plan provided that they come and they talk and they find out, let us know what the problem is. That seems way more reasonable than just smacking them with a late fee and then eventually foreclosing on them for a small amount of money. Other rights. Minnesota does not give homeowners the right to park their work vehicles in the driveway. I've seen people get fined for that too. The recommendation here is that Minnesota should have homeowners, give homeowners the right to park work vehicles in their driveways. The last thing I want to talk about is checks and balances. One of the largest gaps in Minnesota law is the fact that there is absolutely no government oversight of HOA or management companies. There's no check on HOA boards or management companies. No government agency to turn to for recourse. Now, some states require that HOAs and or management companies be licensed and give licensing agencies various degrees of regulatory authority. The recommendation here is that at a minimum, Minnesota should require management companies to be licensed. As I've talked about, 515B, there's room for improvement. No one should lose their home because of a capricious or petty rule, and no one should be forced to pay attorney's fees for asking a question. Other states have managed to implement various different things to protect homeowners. I know from personal experience, my homeowners association, we do things in such a way not to penalize homeowners, but to help them and to guide and be reasonable for the things that we do. I think that we all can do better with this particular statute. Thank you.
Thank you for that testimony, Mr. Morrison. I appreciate that. And again, having a good conversation before our talk today. With that, I do want to make sure we have some time for members to ask questions. Mr. Charbonneau, if you'd like to come back up, please come on up. And then we will ask members or anyone, any of the members online if they have any questions for either of these testifiers. Member Cole. And I do want to make sure that we have time at the end for our recommendations, so please make sure we keep questions and answers concise. Member Cole.
Thank you. We hear a lot about reading the documents before you buy or reading the documents, but most of the time the documents are written by a lawyer and not written in plain language. What do you recommend where we can go for help to get help in understanding what our documents actually say? And then what do we do when the board doesn't follow the documents? Like in our case, the documents say that our board is supposed to be elected, but our board chair has never been on the ballot. So what do we do with that?
Okay, and I will ask either Mr. Charbonneau or Mr. Morrison if you have any thoughts on that question.
Thank you, Chair. I'd be happy to answer that. Member Cole, I know that purchasing into an HOA seems like the only option for a lot of people. And for that reason, the resources are out there. It's my intention to educate more realtors and get them to explain it to the homeowners prior. There was a 3-minute video on one of my slide decks and also a first-time home buyer's guide, which is a short 5-page guide on what you need to know before buying into it. But it's a challenge. I agree with you, but we can do better.
Mr. Morrison, I don't know if you have anything to add, but I guess I would follow up with Member Cole's question on, do we know if there has ever been an effort to either create statutorily or by an organization like CAI to create sort of a best practices set of like a charter or of those governing documents that is written in plain English, or having something that is available that explains in plain English what that actually means? And could that be provided to homeowners in advance so that they actually understand what those documents say? Because I know when you're buying a new home, there are a lot of forms to fill out. There's a lot of papers to read, kind of like when you go to the doctor. And so I do think that often homeowners are not well aware or well versed, and they're probably not looking for a 3-minute video. So I'm just curious if you know if there's any efforts that have been underway to devise sort of a template for what that might look like for boards, and if that's been done or something, and specifically in plain language.
Thank you, Madam Chair. I'll address part of that. First of all, when you buy into an HOA, when you initially put your purchase offer in, you have a period of time. The seller has a period of time, and it's usually the property management company that provides all of the documentation that you're actually talking about. They provide a copy of the declarations, a copy of the bylaws. They're supposed to provide a copy of the most recent budget. They're supposed to provide a copy of the balance statement for the HOA, and that you have a 10-day period to review that in order to see, what the rules and regulations are. Now, do people read that? I know I did. And especially being a previous board president, I know exactly what I'm looking for and to see what the strength of the HOA is and, what the documentation says. One of the things that I noticed too is going from one HOA to another, it's almost like it's boilerplate, because the guide, the declarations and bylaws from the one HOA was very similar to the HOA, to the declarations and bylaws of the second HOA. Whether that happens across the state or not, I don't know. I do believe that we should have some type of standard that changes the bylaws and the declarations into out of legal speak and into plain English, because people, for the most part, have no clue what it says. I know for our board, they're always turning to me as the attorney to go, what does that mean? You know, and then I have to look at it, and then sometimes I have to look at it and really, you know, kind of scratch my head and try to figure out what exactly does that mean? And then to become extremely familiar with it besides that. And I'm sure you've got something to add with that.
I will say I have heard in a few accounts where sometimes there have been instances where actually attorneys and property managers or boards have all had different interpretations of what the statute means
Yep.
and have been given different levels of advice or information on the very same words. So I do agree with you. It is a little bit daunting. Mr. Charbonneau.
Thank you, Chair Bonner. CAI has an initiative to help educate and work with realtors prior to anybody buying into a common interest community. This has been an ongoing thing since the inception of CICs 50 years ago. Some of the references that I did put on the slide deck, there is a helpful website. It's a general overview of operations and topics in plain language on the Office of the Minnesota Attorney General Condo and Townhouse Associations. If you go onto the slide deck, all the URLs should link there. There are some other longer versions in layman's terms. There's a 44-page document if homeowners really want to read about getting into CICs. It shows how they're organized, governed, and managed. But I highly recommend making these materials available to every new homeowner prior to purchasing.
Okay, thank you for that. Do we have any other members with questions? Member Murray?
Thank you, Madam Chair. I wanted to ask, do either of the testifiers have an opinion on what a reasonable, like, max time budget people should have for learning and I guess information and communication? Many people, time is very precious. You can't get more of it like money. And if you're disabled or you have kids or other things are going on in your life, you have less of it, so you have difficulty communication or participating. So what would be reasonable from each of your standpoints for how much time an HOA should take up in your life?
Mr. Charbonneau, Mr. Morrison,
I can go first. Thank you,
Mr. Charbonneau.
Madam Chair. Thank you, Member Murray. That is going to change from person to person, HOA to HOA. Some members may volunteer, may not even know that they live in an HOA until they get their first fine or budget or assessment increase. As far as a reasonable amount of time, I think before buying in, they should spend at least an hour or two learning about a CIC. And the resources are there. I mean, a simple 3-minute video can inform you a bit, but I would recommend at least a couple hours. And then once you're in an HOA, it shouldn't take but, an hour a month just to read some of the periodicals to maintain your knowledge. Now, being a board member, that can be a full-time job, depending on where you're at. So that's a whole different education that I would put as maybe 8 hours just to become accustomed to the basic rules of being a board member.
Okay, thank you, Mr. Charbonneau. Mr. Morrison, did you have anything to add to that?
Thank you, Madam Chair. To echo what Mr. Charbonneau said, it's going to be board specific and person specific. I have an open email policy, and that kind of spilled over into an open door policy because now they all know where I live. So, But that's okay. You know, if I'm out walking my dog or I'm out walking around or I happen to be doing something in the garage, people come up and say, hey, this, that, and the other thing or whatever. If there's problems, they email me. I don't have my phone number published. I did that at the previous one and that was 124 units and I vowed never to do that again. But yeah, I mean, it depends on how much effort you really want to put into it. To be a board member, you have to have knowledge, okay? And especially if you happen to be the board president. You can't just hop into that job because if you do, you're going to be at the mercy of the attorneys and you're going to be at the mercy of the property management company because if they tell you something that's not necessarily correct, you're not going to know it. You're not going to be in a position to argue with them to say, and that's where you get led down the primrose path. So it's incumbent upon anybody, as my colleague here said, you need to take the time to learn. Now, there are property management companies out there that provide schooling, that they have classes, they have boot camps, they have different things like, to teach you about 515B and to teach you about, the laws that govern your responsibilities, albeit whether it's a statutory responsibility or it's a bylaw responsibility. You've got a fiduciary responsibility. Most of the time, that's listed in the bylaws as to, what exactly you're responsible to do in order to keep the HOA solvent, for example. You can't just let it go belly up, so, the more you work, the more you have to study, the more you study, the more you realize you have to work. Okay. So there's not really a time limit that I would say that it's a matter of what you become comfortable with. And then as you find the things that you don't know, then you have to put more time and effort in to learn those things so that you don't get, you don't get led down the primrose path. I don't know if that answered your question completely, but hopefully it did.
Thank you. Thank you, Mr. Morrison. We do need to start getting to the next section of our agenda. So I want to thank both of our testifiers for being here today, Mr. Charbonneau and Mr. Morrison, for your expert testimony. And I think it sparked some good questions amongst the group. I will say on a private note, we know that time is a real issue, right? And we have seen that happen. People are busy. And what we see here is that the crux of the problem is often about this idea of communication and plain language and transparency. And what we hear a lot, if we are really digging beneath the covers of a lot of the more egregious situations we've seen, or even those that maybe aren't as egregious, where we see real communication issues. We see communication issues in where something isn't transparent, it's not clear, it's not written in plain language, it's difficult to access information. To really have folks be informed and be good homeowners, be good board members, be good property managers, be good attorneys, all the way around. And so I do think communication is probably an underlying theme, and we will probably need to make sure that we keep that in mind as we make our recommendations. And that said, we're going to move on to the next part of the agenda, which is to go ahead and get to the recommendations themselves. And I believe Abra is going to take the notes online and have that up on the screen for us. So I will open it up. I think we had actually lots of really good things out of today. But what I'm going to do is give folks the opportunity to come back and suggest anything out of the gate. And if not, I can certainly go to some of the items that we heard today. Any members want to start off today with any specifics on recommendations?
Let's start, Madam Chair.
Yes, Member Daley, go for it.
One of the things I think that sort of shocking was from our first public testifiers, but in terms of this conflict of interest, I think that's already on our list. I can't really see our list from here, but
Yeah.
I just think it's so important to have that there be some standards for management companies in particular and board members too. I think there probably are already out there for board members, but for management companies to just it be very clear in the law that they cannot engage in self-dealing, that there is a standard conflict of interest policy rules about their inability to sort of use their role to benefit themselves and,
Yeah.
you know, that they maybe even have a fiduciary duty to the association or
Sure.
some more robust protections there.
Right. Thank you for that. And I think there's no concern that, that property management companies may have dealt with other vendors before and had good experiences, and certainly they could add them into the mix of potential, bids, but I do think that it is concerning when we are not asking for any competitive bids. We are not asking for any opportunities. Certainly, that doesn't mean you always want to take the lowest bid you get. We all know sometimes you get what you pay for. But certainly having a good spirit of competition could be very helpful. So that conflict of interest is really important. Member Lucero. Or I'm sorry, my apologies, Vice Chair. It appears Member Cole was first. I will go to Member Cole first and then Vice Chair Lucero.
Thank you. I would love to see the nature of the relationships defined, clearly defined. The board is put in place to enforce the CCR. So what is the nature of the relationship between the board and the municipality? But also, if the board, the way the board functions is that of a landlord. So what is the nature of the relationships and how are they more of a definition of what it is and who is involved. Somebody had once said that the board represents the homeowners. Well, no, they don't. Not really. Not in form and function. So, what is the nature of the relationships, and having that clearly defined would be really helpful in all of this.
Okay. Thank you for that. I do want to specify, though, I do think that we do want to keep in mind that many boards are comprised of the homeowners themselves, and many of them are really doing their best for all of the homeowners concerned. So I want to make sure that we're not maligning all board members, because I know some of them really do work very hard and very diligently to represent their members. We've also sadly heard some unfortunate descriptions in this committee of some folks who maybe have not been very good at following their role, but we certainly want to make sure that that is not, we're
Oh,
not
and
clearly saying that of all board members.
well, I
Member
agree
Cole,
that
please make sure
the
you address things through the chair.
yes, I thank you, and I'm responding to your discussion there is that it shouldn't be an either or. Let's codify the best practices and codify the defining what is working and what is working well so that we don't have the exceptions, or there is that standard of conduct that we know that this set of relationships works, and this is the nature of that relationship, and make it available to everybody.
Understood. And I think we should always strive for that. Thank you, Member Cole. Vice Chair Lucero.
Thank you, Madam Chair, and I want to thank the testifiers for the great information today. One of the things that I stood out for me is the term that I absolutely hate in statute, and that is the word reasonable. And so in the context of reasonable fees, I think that we need to look at trying to put some more clarity on exactly what that means. And perhaps for some guidance, because the CIC boards are operating very similar anyway to a city council, again, just trying to draw a comparison, can we look to existing statute for some guidance on the do's and don'ts of what may or may not be charged and potential caps that are in statute on those fees that are permitted? And again, trying to just put some more clarity on the permissible and non-permissible fees. And then instead of using the term, replacing the word reasonable with actual hard numbers or something to that effect. Thank you, Madam Chair.
Well, I am a fan of the word reasonable, but however, I do think what we need to do is make sure that we define what reasonable is, to Vice Chair Lucero's point. Because that can sometimes be a little bit broad and hard to define. And I believe if we're being clear on this, the, requirement is, or the recommendation is really around fines and fees and making sure that we include things like, a schedule of fees. It sounds like minimum or caps for certain fees. Some requirements around interest charged on fees. And I was looking in my notes for the exact place. There was one other thing that also fed into that. So it was interest, schedule of fees. I think it was timelines, if I'm not mistaken, was the other piece that I maybe missed. So, in any event, I think those are all really important pieces around that, and I appreciate the piece around that. Okay, Vice Chair Lucero, did you have anything else that you wanted to add?
Nope, that's all I have in terms of today's discussion that stood out for me. Thank you again, Madam Chair.
Okay, very good. Any other members? Member Green?
Thank you, Madam Chair. Just on the topic of foreclosure, just with some of the testimony and presentations, bringing up some parameters around what is foreclosable. And one of my notes was limiting that to common expense fines and fees. I think that sounds very reasonable. So just, putting some parameters around the debt that is foreclosable and what would be available to an association to recover by other means, a judgment, et cetera.
So the recommendation is clearly spelling out what fines or fees are eligible to be included in foreclosure. I think we also heard some other pieces on there, and this may already be in our recommendations, but about that there should be a reasonable timeline set around foreclosure. A minimum amount, I think, was recommended by, I think, both presenters actually, before we initiate a foreclosure process. I know there has been also a recommendation around notices. And we heard from Ms. Morton that there were very specific items that some states are following around those notices in terms of adding a time frame, the amount of the fine and fee, the delivery method for those notices. And in fact, one state even went so far as to say that if you did not follow the delivery guidelines so that someone received the notice, that you actually couldn't even go forward with the process. I don't know if that's the one we want to emulate per se, but I do think it does speak to that point that we may want to make sure that we have a reasonable and structured process for notification around any fines, fees, or foreclosure. So I think that is all really good. And there was one other, I think.
Madam Chair, can I add just one to that same?
Member Daley, go ahead.
What you're
Yeah.
talking about. I think it was Ms. Morton who, and I had not ever thought of this, and I don't think we've talked about it, but mentioned a state or some states have a requirement that HOAs cannot foreclose on common interest assessments unless they're essential. So I think it was, what comes to mind for me is like, oh, they have a pool, and so now every owner has to pay X amount of dollars to fix the pool. But in my mind, that's not an essential service. So maybe that's not a foreclosable type assessment. Whereas
Okay.
like shoveling and fixing the roof, and those are all essential, but maybe the non-essential.
Perhaps the ability to distinguish between essential and non-essential fines and
Correct.
fees.
Assessments.
or assessments, excuse me. All right, very good. And we also do have member Kimball on the line. Member Kimball?
Yes, thank you, Madam Chair, and thank you actually for your comment, Member Green. That was exactly what I was going to recommend. Just to follow up a little bit more about aesthetic rules, I don't think that aesthetic rules should be a foreclosurable offense or something that results in foreclosure. I wonder a little bit about having some internal dispute resolution process or a right to contest breaking an aesthetic rule in an open meeting and requiring a majority vote of the board. That was something that I heard in presentation today from some of the other states. And I wonder a little bit if there are requirements that we can look to for city process. When I don't mow my grass in the city of St. Paul, I might get a notification in the mail, but then I have a clear statement about how I can dispute getting that letter in the mail. I wonder if that's something that we could look at to apply to HOAs.
Yeah, we also heard a recommendation that the board have a timeline for when they must approve requests, particularly around aesthetic mandates. If someone wants to add new brick to their facade, that they would put that request to the board and they have, I believe, 90 days was the recommendation. So for those boards who maybe only meet quarterly, that would be a reasonable way for all boards to comply with that, right? To give the homeowner some idea of when they could maybe schedule work or have work done, that kind of thing. And I'm not particularly sure how we address this, but I know that Utah had something about limits on aesthetic mandates, and specifically some of those more small things. We hear often things around, you know, having a sign, a flag, whether you can have a wreath on your door. We heard that one, whether you can have a Ring camera. There's some, and I don't know if the Utah law actually addresses those types of smaller items. And I know what I hear from board members, because I've talked to quite a few, is that they really struggle with some of those pieces because, for example, it seems that most people would not have a problem with someone putting up, say, a US flag, right? A Minnesota flag, right? But I think the concern I hear from them is when we talk about reasonable and what's appropriate, do we allow somebody to put up a flag that is hateful, for example? Because technically that still falls under a First Amendment right. We actually heard about our Supreme Court justices in having a flag up that may have been a little bit contentious with some of the neighbors, right? And I'm not going to weigh in on which side of the debate anyone's on that. But I will just say that it does raise questions. And what I often hear from board members is that in their mind, the most simple solution is to simply not allow any, rather than to try and pick winners and losers. And I think that has been a real challenge. And so I do kind of hear that from board members too, but maybe we could look into whether or not the Utah limits on aesthetics has some practical guidelines on what that looks like. Because I know that is something that boards really struggle with. And so we sometimes hear these where, you know, my board says I can't have an American flag, which seems egregious, but at the same time, they're really coming from a place of, I just want to execute fairly the standards among all homeowners. So if I allow it for one, I have to allow it for the other. So we just don't allow it for anyone. And that's generally what I often hear on some of those pieces. So we can look at that. And then we had, Member Kimball, was that all of your question or did we get to it?
I had one more follow-up, if I may. I just wanted to highlight, in the testimony that happened yesterday, I wasn't able to be there, but one of our housing counselors provided some testimony and talked specifically about pre-foreclosure notices. In the state of Minnesota, there's a requirement that housing counseling agencies are notified whenever there is a pre-foreclosure notice that goes out. And currently, some of the pre-foreclosure notices that our housing counselors receive are very basic statements that just say, this is a pre-foreclosure notice, with no information about who the person is, a detailed account statement of what is in arrears, what the options are for preventing foreclosure, what the information is about how to do a repayment plan or any postponement rights. I think that should be part of a basic notification that goes out to any person who may be receiving a foreclosure notice.
Okay, so I think what I hear is on the foreclosure notice that should include a defined what is the fine or fee being assessed, how much, a description of that fine or fee, what are the options for addressing that fine or fee, including a right to be heard. I think I've heard before the board to contest a fine or fee. And then we also had, sorry, my handwriting is not great today.
Repayment plan options.
Oh, repayment plan options. And then also, some information about counseling on that would probably be helpful, on that notice. And I do think current Minnesota law, if I am not mistaken, and Ms. Howard might be able to nod too, I do think it does actually include a number of those elements already in the statute that are required. So if someone is not following that, they are technically in violation of the law. So just to be clear, I don't know if all of those elements are currently accounted for, but we can certainly double check with current statute to make sure. But I do know some of them are already present. So hopefully folks are following that. But, all right, with that, I did actually find, yeah, go ahead, yes. I did actually find the thing about the fines and fees where we were talking about the schedule of fines and fees, setting caps, and transparency around what those fines and fees are. I think we did catch all those points, but that was the notes I was looking for earlier. All right, Member Howard on the line.
Thank you, Chair Bonner. I just wanted to kind of respond to some of the other discussions that we've been having about, limiting fines, fees, that sort of thing. I don't have a problem with saying, you can't foreclose solely on fines, but if we're not allowed to include that in the lien, there's really no enforcement mechanism for associations. With regard to aesthetics, I think that is the number one primary reason that most people choose to live in an association is that there is some control over the appearance of the property, because that helps to maintain property values. So I would caution us against restricting associations blanketly. I think each association should be able to determine for itself what, some communities allow homeowners to really personalize their properties, others don't. And I think each community should be able to make that decision for themselves. We can certainly talk about parameters of, you have to have a policy. But I think I would caution us against trying to dictate what that policy is for every single community. Same with, what is a fine, what's reasonable? If a fine is supposed to be, intended to deter future violations. And so the same fine is not going to deter, if I'm not bringing in my trash can versus we have rental restrictions and I'm going to rent anyway. So I think communities need to be able to have flexibility to determine what is appropriate and what is reasonable for themselves. I agree that they all should determine that and set schedules. We recommend that to our clients. So let's set a schedule so that everybody knows, the board and the homeowners know, if I do this, this is what the penalty is going to be.
Thank you. I do also want to mention, and I will ask, we were running a little short on time, but I will ask, Ms. Morton, she had mentioned also that in regards to being able to do something around repeat fines and fees or repeat offenses, she did mention, I think it was Maryland, that had something about those repeat offenses very specifically in their law, that might be worth researching to see how that impacts the information. So I would suggest maybe that might be something we want to look at, because certainly we also do want to make sure that there is some pathway for homes to keep some set of standards, but also that we're protecting homeowners as well. All right. Do we have any other members with specific requirements? I'm sorry, Member Berglund, right?
Yeah, Bergrund, thank you.
Berglund, okay.
As I'm thinking about what we've been hearing and my experience working in local government and talking to residents that are having challenges with their HOAs, one of the things that's really coming to mind for me is a lot of the ideas here. We have many, many ideas. There's a lot that needs improvement. Are calling for the boards to do more or to take actions. And what we know is that these HOA volunteer boards struggle to have volunteers show up and coordinate and do the work. And so I just want us to think about, as I'm thinking about this, what's jumping out to me is the page 5, the checks and balances recommendations from Nick Morrison. And others have talked about these too, is that one of the major issues that we are seeing, and he defines it as the largest gap in Minnesota law, is that there's no oversight. There's no place for people to go to seek assistance besides the courts, which we know is not really a practical solution for most homeowners. So I just wanted to elevate that as a kind of framework for thinking about this, since we've accumulated so many ideas that really emphasizing how we can deal with disputes rather than create a whole bunch of additional actions that these volunteer boards need to be responsible for. And one of the main concerns, not only the volunteer capacity, but it drives up the costs for homeowners when we have more requirements, because then they have to hire professional managers to do the work if they're not able to do it themselves. So just a thought about focus as we try to navigate these ideas.
Sure. All right, thank you for that, Member Berggren. Apologies. And did we have Member Murray?
Thank you, Madam Chair. I had 3 recommendations, and I'll try to get through them as quick as I can. Relating to Member Bergman's point, I'd like to see the Ombudsman's office mandate extended to help facilitate open templates, documents, and recommended processes, so that we have an open learning community between HOAs in the state of Minnesota. I'd recommend we if not mandate, at least recommend a information collection and communication budget that we ask HOAs come in under. So because either over communication or under communication are both problems. And I've had my HOA ask me to fill out a lot of documents manually when they already had the information. Like, it's basically a mandate to help people solve process problems, to do it automatically instead of defaulting to ask for the information twice. Tell them to only ask once ever. If you have the information, you can't ask again. And then extend the self-dealing provisions of Minnesota nonprofit law to extend to management companies. And like they extend to corporate entities. We've heard repeatedly that issue, and I would, if we don't get the whole thing, I would ask for a minimum of disclosure of relationships.
All right. So that any conflict of interest should include both property managers and boards and should at the minimum include disclosure
Yes. Thank you, Madam Chair.
of conflicts. Okay, I appreciate that one. I'm trying to go through some of what we've heard. I think some of the recommendations we've heard have actually come up in previous items, particularly like open meetings. Make sure that they're transparent and there's accountability. We've talked about no conflicts of interest. We've talked about licensing, all of that. We've talked about notices. We've talked about open meetings and the right to speak, to not be fined for asking a question, whether it's on the agenda or not on the agenda. We might not have the piece about the agenda included in that recommendation, but in other words, I think if it's not on the agenda, what they're saying is that there should be an open forum for questions, is what they're implying. The right to a payment plan and a right to be heard, I think we've covered those. Right to see basic governing documents without fees. Right to notice before any decisions are made on the board or votes are taken. We've already talked about licensing. That came out in today's two. The one thing that we did not hear today, but that I specifically asked about is whether or not we should, and I'm not going to say whether we should or should not, but whether or not we should include sort of a standard list of what needs to be included in common interest community bylaws or charters. And a specification that those documents should be written or have a version written in plain language that should be provided before the sale of a house. And provided to the homeowners so they understand their roles and responsibilities and they understand sort of what's entailed in the community as they're choosing to live in it. Because it feels like many of our questions that we talk about are education. They are about understanding what that looks like to be a homeowner in one of these organizations. And I also would suggest that we may want to consider one of the pieces nobody has been talking about a great deal, and maybe we have a member on the board who would like to speak to this, but we have not done a lot about realtors. And we have not talked a lot about whether there should be a provision that realtors provide some sort of information or standardized information about community living spaces. Again, what are the roles and responsibilities? What does it mean to live in a common interest community? And sort of what are the expectations of living in that community? And granted, that may vary a little bit from homeowners association to association, but there should be a way to get at least a minimum basic amount of information to homeowners when they're considering that purchase, so that that may help. Now, I'm not saying they will always read it. I'm not saying they will always understand it, but it certainly may help set expectations from the beginning for folks who are going into these scenarios. And again, I almost feel like over communicating might be better than under communicating, particularly when it comes to educating homeowners and boards. That feels right. And then we do have folks transitioning to other meetings and we are a few minutes over. Do we have any last comments before we wrap up for today? Member Kimball.
Connected with what you were just framing, Chair, I really like the idea of having some kind of plain language document that talks about what it means to be a member of an HOA and gives an appropriate disclosure about the fees. Potentially, we do disclosures and purchase agreement processes all the time. And I think a little bit about RESPA and TILA and how those laws changed how we have to do disclosures for mortgages. It seems appropriate that there should be something similar for HOAs.
So you're saying in the documents that we provide to a potential homeowner, we should also include, say, a schedule of fines and fees
Yes,
appropriate to that homeowners association,
yes,
so that they are aware of that upfront.
yes. And so that there's some awareness if you don't pay your fines and fees, or if you don't pay for your HOA assessment, then it can lead to foreclosure. And this is what
Yeah.
signing up for this means.
Right. All right. Very good. I appreciate that. Any other comments or questions before we get ready to close? We are pretty close. Member Howard.
Thank you, Chair Bonner. Just quickly on the plain language, I have no issue with the separate document being created. I always tell my boards when they say, can we rewrite this in plain language, the governing documents? I say no. Specific words have specific meanings, and we want to make sure that we are not changing the meaning by putting a different word in there. And so we have like statutory language that we often mirror in those documents. We don't want to change that because that changes the interpretation of the statute versus the document. So I just wanted to put that out there, that there is a reason why specific language is used in those governing documents, but I have no problem with a separate document that puts it in plain language, as long as it's not that actual association's documents.
Okay. All right. Very good. And then, the last thing, any last moments from staff before we go? Just to queue up, we do have listening sessions scheduled for, I believe, January 9th and January 16th. Those meetings, we are still working out the exact location details, but we believe the timing will be 5:30 to 7:30. So if anyone wants to put a placeholder on their calendars, and we do know one will be in Egan and one will be in Eden Prairie. It sounds like that's what it appears to be headed toward. We just will have to provide additional information, and that will be on the website for the exact address of those times and locations for the listening sessions. I also want to make note of our next meeting, and I'm not sure. Okay, all right. Sorry, I didn't understand what that meant, but the next work group meeting is Friday, January 3rd. That will be via Zoom. We are being encouraged, especially right after the holiday and with some of the goings on at the Capitol, to have that remote. So we will do that. And of course, sadly, that means that I will be here all by my lonesome because of open meeting laws. But I will be here. The rest of you may be here via Zoom. But we always want to comply with the law as lawmakers. So very important. And if you want to make sure that you get information on upcoming meetings, times, locations, hear recordings, etc., I want to remind folks that you can sign up for the work group listserv, and that is found on the website, and that is lcc dot, shoot, now I'm forgetting my own thing. All right, thank you. www.lcc.mn.gov. Okay, good, my memory was right. /CICHOA/ and I will have it committed to memory by the time we get done at the end of January. But but in any event, just to repeat, that's lcc.mn.gov/CICHOA/ to get access to any meetings, recordings, etc. And thank you everyone for your time today, and for any folks coming out to the listening sessions. And I do want to remind folks that came up last night that the listening sessions are not required activities of this working group, that the members, both legislative and the members of this work group who arrive for those, are there entirely volunteer voluntarily, and they're cutting time out of their own schedules to be there in order to have the ability to hear from the public and to hear their experiences and their stories. So I just want to be clear, those are not public or meetings in such as we do not make any decisions or anything else. But I think they are very important to hear from the general public. So I just want the public to be aware that those are not legislative meetings. They are not official work group meetings. They are literally there just for us to have the opportunity to hear from the public about some of these issues in which they are very passionate about. And I find great value in them, and I think it informs our work here too. With that, we will be adjourned.